Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibis? Happy Thursday. We're almost to the weekend. I'm so ready. Okay, so busy day here. Lori's hearing was really long, considering the others have not been. And then trying to keep up with the Wagner trial. So I've got to go back and catch up on that. I'll have an episode for you later this evening. Got to go grocery shopping for my Grammy after I get done with this, and then come back and start working on my notes for that. So a couple of things real quick. Thank you to Jody and Sharon for the PayPal donations. I really appreciate you guys so much. And just a really quick music video trivia fact of the day. The most expensive video ever made, Michael Jackson's Scream. You thought I was going to say Thriller, didn't you? Nope, it was Scream. Came in at $7 million for one video. Insanity. All right. So a couple things before we dive into this hearing. I had the honor of designing banners for Tylee and JJ that are on the memorial fence there near the property where they were found. And Miss Janine from Rexburg has been a huge help in getting those printed 3 times due to some typos and autocorrect fails, but finally got them on the fence. And Miss Kay and Larry were there. They were there today for the hearing, by the way, and they were able to stop by and look at those. And these pictures just warmed my heart. And it's unfortunate we need these at all. But yeah, so I'm glad they were able to be there today to be a voice and a presence for JJ and Tylee. Saw our favorite investigators in the back, Hermosillo, all those guys representing the kids. So anyways, yeah, I'm really honored to have done that. And that's a gift from all of us Alibis. So let's get down to this hearing. I'm not super hopeful about all this, guys. I'm just going to be very, very honest with you. So there were a few things they talked about. First couple were really, really quick. But just remember, Rob Wood at one point in the past asked for no cameras. He didn't want cameras in the courtroom. So just remember that. So before it went live, of course, it was late. The parties met in chambers before the start of the hearing to discuss some issues, and we don't know what they were. So there was a motion for Lori to be able to appear in street clothing for these pretrial hearings, and Archibald said this was granted previously, and the state agreed. They didn't object. Motion granted. She can wear her own clothes to her pretrial. The next motion, it was filed on July 12th, and that was to incorporate federal and state constitutional grounds in support of future motions and objections. And Judge Boyce said, I don't think there was a specific response by the state, but I will allow a response. Archibald said this motion is based on the death penalty rules of prudence by the Supreme Court of the United States. And death penalty litigation is ever changing. He said in 1972, the U.S. Supreme Court said death is a cruel and unusual punishment. So states began to modify their death penalty statutes to conform based on the Supreme Court's definition of what is cruel and unusual. Since 1972, Furman versus Georgia case, every 5 years or so in death penalty litigation, there's a change of rules. No death penalty for those who are criminally insane. And they really need to update their wording because it's a very offensive word by today's standard, not by any fault of Archibald. He's reading the rules themselves, but no death penalty for those who are mentally, and I will say impaired. No death penalty unless there's a mitigation investigation. He said, we set forth several federal decisions regarding death penalty in the U.S. and for the purpose for future appeal. In case she's convicted and death is imposed, this will be in appeal for decades. And that is very true. That's, for me, that's why I would be okay with a life sentence, because more importantly, the family does not have to continue litigation off and on for many, many, many years to come. The death penalty in Idaho is rarely used, although the state went for death. That's their choice. I support that. I mean, that's their right to. They've seen these autopsy pictures. They know what happened to these kids. We do not. So I'm not making any case for death or no death. I just say I would be happy if it came down to life, because that way Kay and Larry don't have to do this, and Annie and everybody else don't have to do this for years and years. Archibald said, "We are making the record clear. We want all of our constitutional arguments preserved and all of our constitutional issues litigated. Mr. Thomas won't do any of her future appeals. There will be another attorney appointed in case there's a guilty verdict and a death sentence." I saw Larry shaking his head in the background, just, to think that there's going to be other sets of lawyers with a death sentence, and it starts that whole process. So it says this motion isn't a what if, it's real. Federal judge in Ohio, I'm thinking of Wagner, Idaho, just ordered a new sentencing hearing for Robin Rowe, who has been on death row in Idaho for 30 years. She is the only woman on death row in Idaho, I believe. He said this is important and has to do with Lori's case. 30 years from now, there will still be litigation ongoing if there's a death sentence. I won't be around in 30 years. I don't know if Mr. Thomas will, but this case will be if the state gets their request. That's why my motion was filed. So I think what he's really hinting to there is just they're going to argue, and we get to that in a minute, about mental illness. That is going to be a mitigating factor for her. So that's going to make the appeal process, if she gets death, just more intense and more longer, or more frequent, I guess. Rob Wood said the defendant hasn't waived her constitutional rights. If there are specific objections to be made, it's the defense's responsibility to bring that to the record. Judge Boyce says in lieu of an order, the court will not order some standing continuing objection, but he said he would note there's been no waiver of her constitutional rights. So then we jump to this motion for media. That was an August 30 filing. If you remember, there was a lot of stink about the camera position that was pointed right at the defense's table. There was a microphone that was put on the defense's table. And the state filed a concurrence, which was filed on September 12th, agreeing largely with the defense to ban cameras. So the defense says there's no camera on our desk staring at us. And I noticed there's no mic attached to the desk, and I appreciate that. All of us here have the same obligation to Lori, and that's to make sure her constitutional rights are protected, including her right to a fair trial. The court was concerned about pretrial publicity a year ago. Almost a year ago, the case was transferred over 300 miles from Fremont to Ada County for the media coverage, nonstop media exposure. So can I just say that, to me personally, the pretrial coverage of this case, the least of it to me happens in that courtroom. It is Lifetime movies. It is 2 and 3 part specials. I'm not knocking it. We live in 2022. It's a digital age. This is the new norm, and you can't undo where we are as far as in a technology sense. Things happen fast. Documentaries are put out, it seems like, within days of a major case coming in mainstream media. I just feel like the courtroom, if anything, people tend to focus on how she looked, and that's part of the argument. But the thing is, with this case, I don't care if you move it to Mars. You can't put toothpaste back in the tube. There has been so much pretrial publicity in this case, and it's going to be worse the closer we get to trial. So I just feel like the courtroom's the least of their worries, but that's just me. So the defense goes on to say Fremont County taxpayers will spend more for a fair trial because of the media's nonstop exposure of the case. If the media saturation continues in Ada, where do we go from there? The media exposure is already hitting Ada County. He says in his 13 years, he's never had a problem with the media or had to make any kind of a motion regarding where they put their cameras or their microphones. He says freedom of the press is a constitutional right. It's not infringed by limiting cameras. Federal court doesn't allow cameras. Some states don't allow cameras. Looking at you, Colorado. The overriding interest is a fair trial for Lori, and the Bill of Rights affords her a presumption of innocence and not a presumption of guilt. The state has to prove her guilt beyond a reasonable doubt. Pretrial publicity is that turning the tide where Lori has to prove her innocence and not the state. I want the court to review the last hearing. He explains he tried to upload that hearing onto a thumb drive, but it didn't work. So he said the link is in the state's response, and he wants Judge Boyce to review that last hearing. He says there was one camera in the courtroom, one on the judge, and one on Lori. He said the hearing was 50 minutes long, and 30 minutes of that was zoomed in on Lori. He said, what's the purpose of zooming in on her for 30 minutes? All she did was whisper to her lawyers. There was no point. It was an abuse of their privileges that the media is given. Why wouldn't the cameras be on the attorneys making those arguments? But it was on her. What was the purpose of that? She's been in custody now for over 2.5 years, 20 months in jail, 10 months in a mental hospital. What's the point? To mock her, to humiliate her? Lori shakes her head, yes, of course, but then she turns and smiles at the camera. So which is it, lady? There's no value in it, he says. Does it help us find an impartial jury to focus on Lori's expressions? No. The public, this is key right here, guys. This is what's coming. This is a hint. The public will eventually hear Lori's mental health diagnosis. I know what it is. The court knows. The state knows. There's a time and a place for everything. It will eventually be disclosed, essentially at trial. So banning cameras is drastic. It's not the first time the request has been made in a high-profile case. For example, a few high-profile cases where cameras have been banned was Timothy McVeigh, which that was federal. There are no cameras in federal anyway. Susan Smith, local case for us. Richard Davis, Scott Peterson. And there's been times in high-profile cases where the court has said enough, no more cameras. We can get the information to the public in some other way besides camera. And so I know it's a drastic remedy. So that's why I presented another option in my motion. Let's go back to the way cameras in the jury box were. No humiliation, no making fun. Be respectful. This case is tough enough without sensationalizing it. We don't need any more drama in this case. Real quick, we're going to take a second to talk about our paid sponsor for the week, Glad Skin. If you've been living with eczema, acne, rosacea, you can relate to the frustration trying dozens of products over the years without any long-term relief. With Glad Skin, you can expect something different. Did eczema have you as a kid feeling like you had no self-esteem, embarrassed? Did you lose your sense of self? And did that follow you into adulthood? You deserve better than that, which is why it's time to rethink your eczema treatment with Glad Skin. Skin conditions like eczema, acne, and rosacea affect millions of Americans in the U.S., but the way they're treated isn't working. Glad Skin is rethinking what caring for inflammatory skin conditions looks like by working with your skin and not against it. It's so effective. 91% of users, adults and children, who tried their top-selling eczema cream reported significant improvement in just 7 days. Glad Skin with Micro is steroid-free, works even without harsh ingredients, and is clinically proven to reduce eczema symptoms and is even gentle enough for babies. So if you've been frustrated with your treatment options, don't wait to try Glad Skin. They're offering my listeners 15% off plus free shipping, y'all, on your first order at gladskin.com/whattheworld. That's gladskin.com/whattheworld for 15% off plus free shipping. Gladskin.com/whattheworld. Back to it, y'all. So Rob Wood starts to talk. He says, we're here because Lori and Chad have been indicted for the murders of Tylee Ryan, JJ Vallow, and Tammy Daybell. The trial is set. They're entitled to a fair trial. Prosecutors have a job of seeking a fair trial for the defendants and the state. We want a trial we have to do once. The last hearing, the state isn't alleging malicious intent on the media. They should have access. It's a public right. But Rob Wood says it does concern them about the uneven positions of where the cameras were focused. And when it comes to trial for witnesses, he said that has a chilling effect for witnesses for the state and the defense to know they will be subjected to such public media scrutiny. Archibald mentioned mics on the defense table, and we think that also has a chilling effect on counsel. So we're glad they're not here anymore. It inhibits the ability to effectively litigate, and it's difficult to communicate with those microphones there. They're not needed. In prior live streams, they have lifted audio from the court, and that works just fine. So Wood says the venue has been changed to Ada County, which is the largest media market in the state, he added, which is a really good point. He said, then why change the venue if you're worried about pre-trial publicity? Remember, Rob Wood did not want that trial moved and fought for that. If you're worried about pre-trial publicity, if at some point the rationale is changing the venue, we should limit pre-trial publicity. We are more concerned about the next few pre-trials than the trial. The state intends to file a 404, which is a prior bad acts that they intend to introduce, if I read that correctly. And the defense intends to bring forth a bill of particulars, both of which are fact-intensive motions dealing with a lot of facts of the case. The media has a right to be there. They don't have a right to broadcast. This is Rob Wood speaking. And he said he also brings up case law about the media's right to access the courts. He says it is at the discretion of the courts to decide. He quotes some case law about media access, and he says there's no right for a video camera or camera in a courtroom. Pretrial can create a major problem for a defendant in a criminal case. At the same time, Lori and Chad killed 4 people, murdered 2 children, 2 adults. You're going to have pretrial publicity. It's kind of what happens, especially like we said, in today's world. We got Facebook forums, we've got message boards where people, tens of thousands of people, Twitter, Facebook, everywhere discuss this stuff. Here, right here, what I do. I mean, I get the argument, but then it kind of falls by the wayside for me. This is the least of their worries, in my opinion. He brings up cases about the media saying streaming isn't a right, but the public can attend. And the media can attend and later report on it, which we're seeing some in the Wagner case when these witnesses don't want to be seen on camera. He also cites a case where it says pretrial can be more harmful to the defendant than during the actual trial. He also said that COVID posed restrictions and the streaming needed to happen, but he also says now there are no restrictions. He reiterates there's no right to broadcast pretrial hearings. He said, how do we get a fair trial? If we have to do it 2 times, there's going to be more cost. Then he mentions Kyle Rittenhouse. That's the kid that crossed state lines with guns and killed 2 people or something. I didn't follow that case at all. Where the judge said that he normally supported cameras in the courtroom, but when he saw what was being done, he used the words or the phrase, "It's really frightening." So Wood says, is pretrial publicity worth harming their cases? He said that he wants to focus on the victims and the defendants. So the media lawyer goes up. He says, Lori has rights that must be recognized, but I reject the argument those rights have been or will be compromised by following the orders of this court. But that's what happened August 16th with the location of the cameras and the mics. One lawyer is more nefarious about the media. The other one is worried about pretrial publicity. So he said on August 16th, specifically the date in question, this was pre-approved by this court, the location of the cameras and the microphones. There's a difference in telling the court that it should be open, but only to people who want to physically come and sit. Because if it's broadcast to others, her rights are jeopardized. And then he said the only logic is to suppress information. Now, Judge Boyce interrupts. I've never seen him interrupt like this, and I've never heard him talk in such a forceful. It wasn't forceful, but it was very direct. He said he disagrees. He said public access is allowed. Sensationalism isn't necessarily within the bounds of what access is permitted under our criminal rules and our constitutional rights. Idaho doesn't have a rule that requires that courtrooms have cameras. It's discretion within the courts and the judges to decide if they want cameras. If not, people come in and watch like they have since before cameras existed. If there's so much saturation that presents a presumption of guilt, I'm concerned about that happening here. Then he goes on to say, you've named 35 media organizations, which tells me there's a huge interest in this case. And he said, I'm concerned this goes beyond access. This goes to creating a financial enterprise that revolves around this case. My objective is to ensure there's a fair trial. You can continue, but I disagree with that last comment you made, which the last comment, I believe, was the only logic of why you wouldn't have cameras is to suppress information. So the media lawyer continues and says, I'm not here to argue this court has an obligation to allow this. That's not what I meant. The court has balanced these competing interests. I'm not saying her rights take a back seat. The issue of pretrial publicity, but the reality is pretrial publicity is from what the state has charged and the circumstances surrounding the case. I don't know how banning cameras can take that away. Which is the more accurate prescription? And then again, Boyce interrupts. He says, all the public's seeing is the face of the defendant. And how is that accurately portraying what is happening in this case and not the arguments being put forth? You're ignoring what people are saying, but you're not putting the camera on who is talking. You're putting it on her. The public can the public can gauge every reaction she makes while things are being said. The media attorney says, I don't want to argue every single shot. This is within the control of the court. We reject there was a nefarious motive or action, and we worked with what we were approved to do. Boyce says he completely agrees and doesn't think that anybody in the media failed to comply. So the media attorney says, we're trying to play within the rules, which include the discretion of the court. If the court determines a different process that needs to be altered, I do take issue with that because the media has followed the rules and there were still concerns. We know the defendant's reactions to the proceedings are of public interest, and the court feels there was too much of that. We just want to play within the rules, but I'm not hearing that. I'm hearing, despite the actions of the media, that cameras should be banned. My point is pretrial publicity isn't going away. Exactly. It's not. It's way worse outside the walls of that courthouse, y'all. We all know it. How many of you guys have watched the new Netflix documentary that dumped 2 days ago? I haven't. I've been busy. A lot of you have. That is pretrial publicity all day. It's when you turn on your local news. The story's on. You turn on a primetime show, 2-hour special. It's everywhere. This is why I agree with the media attorney, on this. It's just bigger than this courtroom. So he says, I'm hearing despite the actions of the media that cameras should be banned. My point is pretrial publicity isn't going away. What's more appropriate, an actual showing of the proceedings themselves under what rules the court determines. It is better to allow the proceedings to be shown or require someone to be physically present to report on the proceedings. Nothing interrupted the court that day. He also says court TV had additional resources that include precise microphones. I also believe the argument is misleading. If the microphone picks up whispering, they're shut down. He talks about designating someone who would remove audio if anything was caught, and Boyce jumps in and is like, whoa, 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 whoa. Who does that? Media? The technical person would do that? So Boyce is like, we're going to outsource proceedings. He said, I find that a concerning proposition that I can't imagine I would permit. And then the media attorney says, Boyce says they're not court personnel. If they go out of the scope and leak something privileged, that bell can't be unrung and we could have a mistrial. So the media attorney said it would be someone with jurisdiction in that court who would pay a legal consequence should something get leaked. and there are professionals who are among us the best at what they do. He said the arrangement granted isn't unusual. This court isn't turning this over and hoping this just goes well. That's what Boyce said, actually. Um, so I agree with Boyce on this. You're not going to give some dude that works for a media company the right to go in and clip out maybe some confidential conversations. I totally get that point. For me, if you're watching the Wagner trial, that camera in that courtroom is it's controlled elsewhere. So there's no camera person panning in constantly on anybody. And when something is on camera or something's on the screen that shouldn't be shown, if you've been listening to my coverage, it shows you that hand painting that freaks me out. But maybe a compromise is a camera that is remote controlled. I don't know. So he said these mics can siphon out inappropriate information. And Boyce interrupts and says, who makes that determination? Is it me? Is it counsel? So the media attorney says, we're asking the court to exercise the discretion it has as far as where things are. Multiple cameras would be good. The goal is to avoid distraction. We respectfully submit 2 to 3 cameras. Our goal isn't to move them. So if the camera is showing something and we see confidential communication, we shut it down. We go to another camera. If the court sound system is picked up by everyone for better or worse, these mics don't do that. He said court TV has the ability to provide mutable mics if the court wants that. Ultimately, Boyce says he's going to take it under advisement. Archibald said the media's argument of being in compliance with the court orders, he said the orders actually weren't specific enough and we let them police themselves. They put microphones on our tables and cameras in front of us. I've never seen it. The court has the discretion to modify these orders. He said the media crossed the line and that's why he made this motion. Rob Wood finished up and said the harm is assumption. We are paying more for this trial because of pretrial publicity. The state's position is to remove cameras from the courtroom. If they're not removed, we ask to be informed of the location of the cameras before any hearing takes place. And that was the short and sweet version of this hearing today. I really don't know what's going to happen, y'all. I think it could go either way, but if you watched this today and you kind of heard the tone of Judge Boyce, I would not be surprised if cameras are not banned for any more pretrial hearings, and then we just get written statements of what happened through news agencies. But we will see. I don't think it will take very long for this ruling, to be honest. I'm sure they want to get this over with, but man, just a hot mess express, that one. Lori today, I mean, she was a little more subdued than she was last time. And I don't know if Archibald talked to her, if perhaps she's being medicated a little more before court hearings. I'm not sure. She did write some things down and kind of nudged the attorney to her left and giggled and laughed. And she's not acting. Well, I don't know. I mean, because if you watch her when her attorney's making the argument, she agrees and nods her head. And then the rest of the time, she kind of looks like she's in La La Land. Whether that's an act or not, I don't know. But it was a little bit different now. So last thing before we go, I got a red arrow pointed at Larry Woodcock right there because when Lori walked out, he turned and followed her. And if he had lasers coming out of his eyes, that would have been bad for Lori. He watched her until she was out of sight, sending a clear message. They are there for JJ and Tylee, even if this is a hearing about the media. So anyways, that's it, guys. I will be back with you later for day 3 of the Wagner testimony for today. And a few people, family members, have allowed themselves on camera. Not sure what happened after lunch because I've been doing this since. But we'll see you later tonight. Hope you have a good one.